The questions that need to be and should be posed to experts need to be focused on the right area of challenge. Because what we know from the case law is that the underlying science behind this form of testing is sound. So if you cross-examine an expert, which happens too often, about whether or not the computer might be wrong, or the lab equipment might have failed, or the samples might have got mixed up with another sample, it's unlikely to be fruitful. The area where there is and should be successful challenge is about how the results are interpreted, whether or not the drugs found in the hair equate to active use or chronic use. And there are very many areas where that is subject to successful challenge. In my cases, for example, if there's a cutoff level, does that person have, is that person black with a high melanin content? Has that person used hair straighteners? Has any of that been factored in? What relevance might hair dye have? Because if that expert has not taken a forensic history and factored that into the analysis of what the results mean, then it's open to you to take that history and that context and put it to the expert. Just a few examples. I successfully cross-examined a expert witness who was not the author of the report, but spoke to the process. And I believe that she'd turned up to court expecting me to say, "You put it in the wrong packet, haven't you?" But I asked questions like, where is the photograph of the test site that shows how much hair was left on the scalp? That was important because the key issue in the case was when my client stopped using drugs. And of course, if you leave a bit of hair on the scalp, then you might be talking about a different test period than the one that they claimed. She said they didn't take a photograph. So I said, how do you know how much hair was left on the scalp? And she said, well, they would have done it. And the judge is like, I'm not interested in would have. I want to know in this case, where this is a key issue, how much hair was left on the scalp. And she had to say, well, I can't help. The judge couldn't reliably say or conclude or find that that was a reliable result. So the areas of challenge that can be and should be pursued are looking at what factors has that expert taken into account when concluding that this result means positive use. And if the answer is it's simply above the cutoff level, then the areas of challenge are numerous and effective. The right way to go about challenging this evidence is not to challenge the underlying science, because the case law tells us that the underlying science is sound. Successful areas of challenge are around the way in which any drugs found in the hair are explained or analysed and presented to the court as being use or exposure. So we know from the research that there are a number of different factors that can affect how and why drugs are in the hair. And if the person that's presenting that report to the court with reference to cutoff levels, so above the cutoff level it's use, below the cutoff level it is exposure, then they haven't factored in all of those relevant factors. That is a very fruitful area of challenge. And that is the way in which this evidence can and should be tested. Hair strand testing evidence, as we've established, is expert evidence. That's established in case law and it's clear. We don't treat it like expert evidence. We don't say, you're the expert, this is the information that we require. What we need to be doing is taking a step back from being that prescriptive and instructing experts as they are in the way that you would instruct any other expert. So we need to start instructing this type of expert evidence as experts with a letter of instruction, asking the expert to take a full forensic history, asking them to factor that into their analysis, trusting them that if they need to test for a longer period than 3 months to get a 3-month picture because of patterns of usage, that they need to do that. instructing them to take a nail sample at the same time as well, so that if there are difficulties with the hair or there's contamination, the nail sample can be tested as well to provide more clarity. So in short, we should be doing exactly what the Court of Appeal and the High Court have told us to do, which is instructing this type of evidence as expert evidence